Hello, YouTube. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We're going live maybe for at least 1 hour, I think. Maybe longer. We'll see. I gotta drive to the farm, but we'll see. Oh, we got a lot of questions going here. Holy guacamole. Okay, I was gonna try to be funny for a minute. Well, questions piled up, but I was gonna fail anyway. So let's just go ahead and answer the questions. We got YouTube user Palencia, who says, "Is it appropriate to ask for a minute for rebuttal to raise your object to something so you won't talk over defense counsel?" What's the context? Are you at trial? Like, are you a non-attorney representing yourself at trial, or are you at mediation? What are we talking about? What's the context for when you're waiting for defense counsel? Palencia goes on. I found a case, retaliation causes, that settled last year for $7.1 million in retaliation cases, and that guy was making less than what we were making, up to $75K a year. The guy in the lawsuit was. Okay, great. Keontae Johnson says, "I've been going through the court process with my employer since April, and I just received news that he's retiring. Will it have any effect on my lawsuit?" Well, is your employer, is like the business owner retiring? Is the business going under? Or is the bad actor who did bad things to you retiring? Which is it? Because if it's just the bad actor, that's great. He might not be available to even testify at your trial. Could be a big advantage for you. If the employer is retiring, you got to keep an eye on, is he selling the business, or is the business going under, or is the business going to keep going with someone else? And, who's got that liability? You're going to have to keep an eye on that. Palencia is going on. "I'm willing to discuss my case with you without creating an attorney-client relationship. I had done the consultation with your firm, but I was turned down for filing pro se, and I understand. I'm sorry about that. We generally don't take pro se cases. I do apologize for that." Palencia goes on. "Nobody wants to clean up another person's mess." Yeah, that's true. I'm so sorry. So pro se, when you file pro se, it does introduce a lot of risk and a lot of additional labor for firms like ours. So I apologize if you were pro se and we weren't able to extend you an offer. I don't really talk about cases here, but, I'm sorry. So Palencia goes on. "I'm willing to hire help if any attorney would be willing to invest their time in my case." Listen, I'm sure an attorney would take your case on an hourly basis. That's not what we do, right? We want to win our money, but there's always going to be an attorney who wants to take your money. I'm not saying I don't have any knowledge of your case. I don't have any knowledge of the conversation. I'm just saying, if you're looking to pay, I'm sure you can find a local option to represent you. Generally, there's many, many, many attorneys, some of which are even good, who will take your money and, do their best for you. Or, hopefully do their best for you. YouTube user John Craig says, this seems like a non sequitur. Oh, okay. It was a mistake. John Craig says, "My buddy..." "My buddy filed an EEO complaint for a position he was passed over for. Through mediation, he got the position, but no compensation. 10 years into the position, a new management comes into the scene and reassigned him to another assignment, but no loss of pay, just a lower reputable assignment. Can he make a case for reprisal? Same agency, but different players." Can he? He can try. I don't love that case because it's probably... There's two issues with that case. One, different people involved, so the retaliation case is a bit iffy. Two, was there actually a negative workplace consequence? And the answer is maybe, right? Because he didn't lose any pay, but you're saying the position is less prestigious. So, is that a negative workplace consequence? I would argue yes, but that's a complex argument with a little bit of risk attached. Lakers in 5 says, EEOC investigator reached out to me and said, they fined for me. What would I be asking for? What do you think that's about? Yeah, they're not offering to fine for you. What they're saying is, do you want to settle this? They're asking if you have a settlement amount. And then they'll probably take that settlement amount to the other side and see if they can get the case settled or schedule a mediation. I suspect that's what's happening. I'm not saying they won't fine for you, but like overwhelmingly, they're just going to issue a right to sue letter. There's not really a finding for process in the EEOC for most people. I posted a video a week or two ago that like out of the hundreds of thousands of cases the EEOC had, or however many they had filed like 100 litigations or something like that. So odds are you're getting a right to sue letter. YouTube user GB says, can an employer claim an accommodation is an undue hardship if they admitted to encouraging it and allowing it to frequently happen? Doesn't that contradict their undue hardship defense? I mean, potentially. It depends on the context, right? If you're saying like, hey, they always encourage people to get help lifting heavy things, and you have an accommodation like, hey, can't lift more than 50 pounds alone. And they're saying, oh, that's unreasonable accommodation. It's an undue hardship for us. But they've been encouraging people to buddy lift things over 50 pounds anyways. Then yeah, that's going to be a terrible argument for that. That's going to be really hard for them to make. And I think you're going to be sitting pretty. But it always depends on context, right? YouTube user Bubblegum says, hi, Vince. Thanks for coming on to help us out. I appreciate you. Gotta shake this cough. Bubblegum, I appreciate you as well. GB says, Vince, good to see you. Hope you have a great weekend at the farm. Thank you so much. I'm going to head to the farm very shortly. As soon as the live stream is over, I'm going to head to the farm. Kind of just waiting for traffic to clear, in all honesty. Bubblegum says, I'm going to file a civil claim. I'm doing this by myself. I don't have representation. That sucks. I wish you had representation, but I'm sure you'll do good. When I filed, do my court filing, I filed in the state of the headquarters for the organization. So there's some considerations as to where you file. The easiest answer is where you worked, but there's also some additional things to think about, like the best set of laws for you, diversity jurisdiction. There's a lot of things going on there. So this isn't really something I'm going to be able to answer for you in a live stream. The simplest answer, which might not be the most advantageous, but the simplest answer is always just the state you worked in. YouTube user Kelsey says, good afternoon, counselor. Have you ever heard of a company hiring a hitman to kill a plaintiff? I have not. I have received death threats from certain companies or certain individuals working for certain companies. But to the best of my knowledge, no one's ever hired anyone to kill a plaintiff or me. Or if they did, whoever they hired was fairly incompetent. 3NV Tati says, my employer filed an EEOC complaint against my employer. I filed an EEOC complaint against withheld my final paycheck for 7 days. Could I use that in my initial interview I have set in the next 30 days? Yeah, you can use it. It's not going to move the needle a lot, but you can absolutely use it. Generally, most state labor departments and the federal government, generally, check with local counsel. Generally, if it's not more than 2 weeks late, they just don't care, which is wild, but also has been my experience. Superficial Look says, when I start this, the cough is so bad, and then it kind of gets better over time. Top advice for submitting or holding certain evidence for or from the EEOC. I would check out our Rebuttal Writing 101 and our evidence playlist. Both of those are going to be the best possible response, way more built out, hours of footage, hours of advice, way better than I can do this moment. Super, not to reference your name, but super superficial answer is give some highlights. Give some highlights to make the other side afraid, but don't give your whole evidentiary body all at once. Unbeknownst guy says, when defendants file summary judgment and you have corroborating evidence in the position statement and multiple claims addressed, how likely is judge to dismiss case? Depends on how well your case. I mean, so I don't know anything about your case, but you need to have a question of fact. So you need to know the elements of your case, and if there are legitimate questions of fact as to the elements of what you have to prove to win your claim, then summary judgment is not going to be granted. That's generally the answer. I can't give you odds on a case that I don't know anything about. That just would not work. Superficial Look says, I need advice for negotiating your own damages. What is the best way to negotiate? So and in Superficial Looks, you're asking very general questions. So I'm giving you playlists because they're way more built out. I would hit up our mediation preparation playlist. I would also hit up our damages calculation playlist. Calculate your damages so you know what you might hope to win, and then hedge for risk when you're negotiating. And lastly, and this is going to be a little counterintuitive, but I know you're representing yourself, but I would look up our playlist on having frank settlement discussions with your attorney. Because if you don't have an attorney, the person you're having frank settlement discussions with is you, right? You need to have some hard conversation with yourself about your appetite for risk, what you need out of this, what you want to see out of this, all these things. YouTube user Kevin B says, how long after my lawyer files until I get an idea of what's going on? Well, the employer is probably going to have a period of time in which they get to answer. So they're going to be working on the answer. They're probably going to be hiring counsel. There might be settlement discussions in those first 2 or 3 weeks after the filing. I don't know if your lawyer reached out before the filing to have settlement discussions. Often many firms do. I don't know if yours did or not, but if there was no conversation, or if the employer thought maybe you wouldn't actually file, but now you have, there might be, settlement discussions there. Once they've answered, you're probably going to have a schedule set up for litigation. And yeah, we have YouTube user Big Bick with a B Dallas, Big Bick Dallas, like Bic lighters, I presume. I don't know. Hey Vince, my employer initiated my resignation email because I would not relocate instead of just firing me. That sucks. I'm really sorry. Also, Vince, if the employer's position statement is different than the response they gave to the unemployment, can I use that in my rebuttal? And does the EEOC take that seriously? You can absolutely use it. It may be useful in certain contexts. The EEOC would care about it if it's useful in terms of degrading your employer's credibility or helping you prove some element of your case. Rebecca Baldaws says, I have a firm and originally had one attorney and they gave me another one. So now 2. That's amazing. I really think that's a good idea. I think that cases should be worked by teams of attorneys. We work every case as a team of 3 attorneys here. And I applaud the firm you're working with for giving you 2 attorneys. That means, listen, they thought there was more to be done in your case. And it also means they may have a training environment, right? Like it's really good to be working in teams because it helps younger associates to be developed in this field. And we don't have enough attorneys in this field. It can be very expensive to do that. Many firms cannot afford to do that. So I applaud the firm you're with. That is heartening and good news, I think. NYC Damages says, appreciate you, Vince. I appreciate you, NYC Damages. These live streams really help us get perspective and insights into things we aren't familiar with. Employment law, but also EEOC workers. LOL. Thank you. Listen, happy to help. I hope I am helping. Max Slavin says, Vince, you always say you're only licensed in New York. Just curious why you've chosen not to expand to all 50 states and be nationally licensed. I don't have to. I have a local counsel network. We have a number of attorneys who are licensed in many places. It's just more cost effective, I guess time effective, to associate with local firms in all 50 states than it is to expand out. Also, like even if I was in all 50 states, that wouldn't really get the job done because all of my attorneys here would have to be in all 50 states, and that would be a massive undertaking. It just makes more sense to have local counsel. C-Note 1906 says, "Hi, Vince. My attorney and mediator told me that I should refuse the offer to go to trial. That I should refuse the offer, I assume settlement offer, instead go to trial. When less than the offer, I'm on the hook to pay the other side, my attorney. I'm in California. Is this unusual?" Okay, so listen, I can't advise. So here, I think I misread that. I think that the mediator, your attorney and the mediator told you that, oh, if you refuse the settlement offer and choose to go to trial, and when less than the settlement offer, you will be on the hook to pay the other side and your attorney in California. Listen, I'm not allowed to tell you the laws of California, nor, frankly, do I know the ins and outs of California procedure and law on this particular topic. Even if I did, I wouldn't be able to tell you without a local counsel present. But here's what I'll say. This can happen as a confession of judgment in New York, where other side comes to you and they say, hey, we want to pay you X amount of dollars. Like, we'll call it, I don't know, 200 grand. And they do it in a way that locks it in. Whereas if you go to trial and you win less than that, you're on the hook to pay some of their attorney's fees. That is a reality that can happen in New York. Can it also happen in California? I suspect it can, but you need to check with local counsel. If your attorney is saying that that's what's going to happen, I would potentially believe that to be the case, but I would also check it with other local attorneys because it sounds, like you may not fully trust your attorney, and that's a concern. So check with, other attorneys in the area and make sure that is true. YouTube user Ramona Hudson said, scrolling chat, losing. Ramona, come back. Where'd your question go? Ramona Hudson says, thanks, Nick, for all of your wisdom. My case did settle, but not nearly what I wanted. I don't know who this Nick fella is, but he sounds great. Superficial Look says, if the EMP refused to give, like an EMP bomb, like the power goes out, or like the employer. I assume you mean the employer. If the employer refused to give adequate accommodation, but gave a few useless accommodations, and they were advised that what was given does not help, is not enough, is this also discrimination for disability? Yeah, that can still be a failure to accommodate. Listen, it all comes down to what's reasonable, right? Is the accommodation you need reasonable? Right? If they're granting you accommodations that don't work, they're not granting you accommodations. That simple. As long as the accommodation that would work is reasonable, then you would have a failure to accommodate claim. All right, let me check my email really quick. Checking the email. All right. And I'm back. All right. Y Thomas 777 says, good afternoon, Attorney White. Good afternoon, Y Thomas 777. I was told pretext can help my case if I can prove the defendant submitted a different response to the EEOC complaint than to the court complaint. Is this correct? Well, if they're saying two different reasons why they terminated you, or their story as to why they terminated you or took some action against you doesn't add up, then yeah, that can certainly help you prove pretext. Open and Shut says, my attorney is sending the demand letter after 1 year of waiting versus WFC. I don't think I'll get what I want in mediation. If I signed a mandatory arbitration, is there a way to go to trial for a race and retaliation case? San Francisco. So you got to check with local counsel, but California may have a statute striking down mandatory arbitration. Don't quote me on that. And I'm also not allowed to tell you if they do or don't. But they may, so I would check that with local counsel. Shanice Robinson says, does firing your attorney 4 months before trial make you appear difficult and favors the company's false narrative of you? Yeah, it certainly could. I'm sorry. Yeah. I mean, it could, right? Like it all depends, but it could. He has no idea what he was doing. Luckily, I found another one 1 day later. So that's good. right? If you're just switching attorneys, that's not that big a deal. If you're having like a public fight with your attorney or like some kind of big, row with your attorney, that could be problematic for your case. Kind of shows that maybe their narrative about you has some merit. Sounds like you handled it really well, at least as well as you could. So awesome. YouTube user Carlos Gomez says, "Hey Vince, a collective action lawsuit approved from the Western Court of Tennessee. Incredible. Congratulations." Oh, I think my mute was on. All right. YouTube user Nico Gomez said, "I submitted an audio evidence to the EEOC from a case that was dismissed or closed, and now it was emailed. Now I was emailed that the audio was updated to my case file. Should I continue to look for representation? And would this mean my case is back open from what they heard from the audio?" So listen, if they already issued your right to sue letter, like they closed your case and gave you a right to sue letter, no matter what they're saying, unless they are explicitly telling you in writing that the case is back open, they're going to issue you a new right to sue letter that's going to comprise the same claims that you already litigating. Unless they're specifically saying that to you in writing, your right to sue letter clock is ticking. Oh, somebody gave us money. Okay, Stan Jokes said, and first off, you don't have to give me money. I'm going to answer all the questions. At least I'm going to do my best to answer all the questions. You do not have to give me money. I appreciate this. Thank you very much. Very gracious of you. But like, keep your money. I'm trying to do my best. I'm going to try to get everybody answers either way. Stan Jokes says, "Hi, on what basis do firms generally take cases on pre-litigation only? Do some only consider trial after they see someone's personnel file? Thank you." I know a lot of firms who I've convinced to take EEOC cases will take the EEOC with the federal litigation as a probably, right? Like if something goes wild in the EEOC, like it turns out the client's lying or like they didn't know about something like that kills the case, they just won't take the case on the litigation. The personnel file is not really that big a deal most of the time, in all honesty. It's generally a lot of people want to see the EEOC case play out. And then if everything goes well, they just go ahead and take the case to federal litigation. There's definitely agency filings that don't go well. You're just like, hey, you know how you said this was discrimination? Why'd you make fun of that guy every day? Are you sure he doesn't just hate you because you make fun of him every day? Like, it might not be discrimination. It might be he just hates you because you're a jerk. Or like the sexual harassment case where it's like, why are you stalking this guy that we're suing for sexual harassment? Like, why does he have 3 orders of protection with 17 witnesses that you won't stay away from his house, right? Like, you get those cases and you're like, yeah. So I really want to help you. But turns out we're not going to take this to fed litigation because you have been stalking this fella for 9 months. And I'm afraid you're going to go to jail. So that happens. Otherwise, no, the personnel file is not a big concern. What do we got? Shanice Robinson said, "Do you confiscate your client's phone?" No, never have. If they asked you for their property back, would you refuse it? No, never would. We've had situations where clients had trouble getting evidence off their phone, and we have briefly worked with them, assigned either an IT specialist, a forensic IT, or just one of our paralegals who's very good at this to help them get stuff off their phone. But no, we don't take or keep anyone's phone. Palencia said, "Judgment not granted would be good if you're opposing counsel." Okay. Superficial Look says, "Vince, if violations are found, what happens next to the EOC?" So, okay, you go on. Like, do they just say it's time to pay up? Like, what happens after it's decided in your favor? Disability discrimination. So, Superficial Looks, in rare instances, I think like around 100 times a year, they might file litigation for you. But generally speaking, no matter what they find, they're just going to issue a right to sue letter, which lets you go on to federal court. and file your case in federal court. NYC Damages says, when you file a lawsuit, should you add all the claims, even the very small ones that help to prove retaliation, for example, and indirect evidence claims point by point? Can you add if you forget one? Yeah, you can amend your federal lawsuit generally. I think you have a period of as right to amend, and then after that, you can seek leave to amend further. You would bring all the claims that have value and all the claims that give you tactical advantage is the simplest answer. Why Thomas 777 says, good afternoon again. If the defendant submitted a false affidavit during discovery, a false affidavit during discovery, can or should I move for an immediate summary judgment? No. The false affidavit isn't grounds for summary judgment. The false affidavit is, it's a sworn statement, so it's perjury. You could look at perjury, bringing perjury claims against them, and addressing that. But like, you probably use that in depositions to destroy their credibility. Big Bick with a B Dallas says, if discrimination is found, can I use threat of trial and reputation as leverage for a larger settlement? Fortune 50 company. You can. We have videos on the channel. You have to be very careful about how you do that. You have to make sure you do it in an ethical fashion, in keeping with the rules promulgated for this kind of thing. Just be aware, you got to steer clear of blackmail, stuff like that. YouTube user Kelsey says, Vince, do you do metadata analysis on discovery documents? Is metadata good evidence? I personally do not, but we do have people here who are good at that sort of thing. It can be useful occasionally. It depends what you're trying to prove. It depends what your elements of your claim are and what you're trying to prove and what the specific arguments and context of the situation is. AR American says, hey, Vince, to which I say, hey, AR American. Rebecca Beldaw says, thanks, boss. I am nobody's boss. That's not true. I guess I am some people's boss, but I am not your boss. I am merely a person on the internet. AR American says, how much longer will you be live today? At least 32 minutes. Maybe an hour and 32 minutes. Somewhere in between there. Hold on. I'm going to take a quick break. Something really funny happened today, and I want to read it to y'all. So the Brooklyn Nets are an NBA team here in New York, and they hit me up and they're like, hey, you used to have a box at Barclays, which is true. Oddly enough, I got my box. You guys remember the Fire Festival, that fella who made a fake music festival called the Fire Festival and then went to jail for it? Yeah, that guy got me a box at Barclays like a long, long time ago before he went to jail. He arranged a deal with Barclays for me to get a box from the Nets, and the Islanders were at Barclays Stadium at that time. Anyway, I only met the gentleman a couple times. Not a friend of mine. I think he's done his time. He's back out in the world. Not saying anything good or bad about the fella. Just he arranged a deal and I got a box. That's it. So Barclays was like, hey, do you want your box back? And I was like, I don't know. You don't really have the Islanders anymore. I don't know. I guess I can entertain clients at the box. People want to see the Nets. I don't really know that too many people want to see the Nets, frankly. And then they were like, well, you can get a box for the women's NBA team. And I was like, I think I'm all right. I don't know if I want a box for either. Well, how much does a box of the Nets cost? And they were like, well, let me read this to you. A Nets full season box, so 29 games. I don't know if that's 29 games remaining. With access to the Qatar Club, which is all-inclusive, non-alcoholic, and food. $45,445 per seat. It's not even a box. Not even a box. That's just for a seat. Now, if I wanted access to the Crown Club, this is for the Brooklyn Nets. The Brooklyn Nets. If I wanted access to the Crown Club, which is like a major food group thing. Like you get to go to Carbone if that's a restaurant that you think is good. You can go to like it's all inclusive food and beverage, but a little bit nicer than the other one. They want $90,015 per seat. Per seat. $90,015 per seat. That is per game. Hold on. Let's do the math here. We got $90,015 divided by 29 games. That is $3,104 rounding up per game. Per game. I'm starting to understand why Barclays looks so empty when you watch a Nets game on the television. In what world? Who is paying $90,000 per seat for season tickets to the Nets? You can get NFL season tickets for my beloved Buffalo Bills at a fraction of a cost. Not even 1/10 the cost. What? Who are these people? And who? What world did they think I was going to spend $90,000 per seat for Brooklyn Nets tickets? It's not even a box. It's just 2 seats. Just $90,000 per seat. $180,000. Sorry, maybe that wasn't fun. That was just insane to me. Absolutely insane. Okay. Let's get back to questions. What have we got? Where were we? YouTube user Mustafa H says, "Hi Vince, my lawyer filed a claim for discrimination and retaliation while I was on workers' comp. I got cleared to go back to work 5 weeks ago, and my employers created a new required doctor paperwork and takes 1 to 2 weeks to respond to me in the interactive dialogue process. I emailed my lawyer 3 days ago, but I guess he's busy. Could such an action possibly double or triple the case? I swear I wish I'd hired you." Listen, don't worry about hiring me. As long as your attorney's good, that makes me happy. This could be retaliatory. Could be further failure to accommodate. Certainly it makes your case stronger. I don't want to talk about the valuation because I don't know anything about your case, but like certainly could make your case stronger. YouTube user GB says, "If there is a conflict between who was responsible for the breakdown of the interactive process, can a judge dismiss the case, or does it have to head to trial?" Well, if there's do you mean like there's a question of fact as to whether you or the employer was responsible for the breakdown of the interactive process? If that's a real question of fact, then it's got to go to trial because a jury or a judge or an arbitrator has to decide, was it your fault or their fault, right? Like it's a question then of fact. So it would have to go to trial. Excuse me. YouTube user Bluegrass State says, "Court of Appeals, what does scheduled motion mean? I won the appeal and the defense filed an appeal." Sorry, I don't do appeals law. I don't answer a question about appeals. You got to go to a specialized appeals attorney. When we have appeals work here, like we're defending a verdict that we won for someone and we don't want it to get appealed, we hire specialized counsel, specialized appeals counsel for that. No question. Apologies, did not want to blow my nose on camera. Samuel Rajasakar says, "While the lawsuit for wage theft was going, I was fired. I got a letter that I am not working out well with the team. I immediately filed through e-filing. Lawyer was not happy. Will he quit?" You filed a letter through e-filing onto the court docket instead of talking to your attorney? I mean, he might quit. Why'd you do that? Why'd you hire an attorney if you're just going to file random things? That doesn't, I mean, I don't want to give you a hard time, but like you hired the attorney for a reason, I presume. Talk to the attorney. Let the attorney earn her or his, fee. They work for you. They're supposed to be reducing risk and adding value to your case. Don't just do, random things without talking to your attorney. I wouldn't fire you as a client for that, but I would not be happy with you. And we'd have a conversation about like, hey, why'd you hire me? Why'd you hire me if you're going to do random stuff? Like, just a thought, right? Mustafa H says, oh, no, we already answered that. Jim Sullivan says, does a material breach of labor contract negate the severance clause within the contract? Meaning we can sue for additional damages. So it's certainly possible that a breach of a severance agreement could allow you to pursue damages again, potentially. That is theoretically possible. That's not what you said, though. You said, does a breach of a labor contract? So is it like a separate labor contract, and then you also have a severance agreement? I don't know the context there. I guess, I mean, listen, is it theoretically possible that it could invalidate the severance agreement? I guess most of the time I'd say probably not, but it's going to be context driven. You're going to have to check with local counsel. Bubblegum, thank you so much for telling people to hit the like button. We have 62 concurrent people in chat and only 18 likes. Hurtful people, very hurtful. The like is how people in the algorithm find us. So I do appreciate it when you hit the like button. I hear it's free. I hear it costs you nothing. BMCK, YouTube user BMCK. Whoa. Shanice Robinson gave me $2. Shanice, why are you giving me money? All right. Shanice, do you have a question that I can answer for you? Whoa. Okay. Chat is being funny. Let me. Oh, boy. Lots of people giving me money. Why are all these people giving me money? Very kind, very gracious, all of you. I thank you very much. I'm going to answer all your questions anyways. You don't have to give me money. It's very kind. Thank you. It is good for the algorithm when you give us money, and I appreciate that very much. I am by no means poo-pooing your gift. Thank you so much. I'm here to help no matter what. You don't have to pay me. Okay, let me go back. Carlos Gomez says you couldn't hear the answer to his question. Carlos, can you ask the question again? I will answer it again. I apologize for that. I think I had the mute button on. Trying to find where I was in chat. BMCK says, if one has a race discrimination and a retaliation case in federal court, halfway through the discovery process, prior lawyer withdrew. I am unable to find an attorney. What can I tell judge at next hearing to get additional extension of time? Advice, thank you. I mean, listen, if you can tell the judge you need more time to find an attorney, that's probably the best thing to tell the judge. I don't know if you've already done that, but if you haven't done that yet, judges want you to have counsel a lot. Almost always, they want you to have counsel. It makes their life so much easier because the attorney knows what they're doing. And I'm not saying you do or you don't, but I don't know if you've ever done this before. And it can be really frustrating to try to bring you up to speed to get your case to move forward. It creates a lot of extra work for the court and opposing counsel. But who cares about opposing counsel? So, like, just tell them you need time to find. You're like really passionately looking for an attorney, and they'll probably give you more time. Rebecca Baldaws says, Vince, my federal employer gave me a reasonable accommodation, but didn't follow it. I filed another one and was then denied. I appealed it on October the 31st, Halloween of 2024. And I have yet to hear back from HR. Today I was sent another reasonable accommodation packet. Sounds like a claim. It's going too long. Sounds like they're messing with you. I think that's a potential claim. Might make sense to speak to an attorney. Superficial Look says, my charge advised of discrimination in my charge advised of discrimination. In my rebuttal, I advised on the retaliation, hostile work environment, exasperation of disability, etc. Would the one charge suffice for multiple violations? Well, you're going to want to set out in your charge of discrimination. I assume you're talking about the EEOC. You're going to want to set out the events that you experienced. So you can have multiple claims in the same EEOC filing. That's not an issue, but I would, in that EEOC filing, have a timeline that includes the events you experienced, all of them. YouTube user Stephanie Patterson said, I filed an EEOC charge back in April. I received my employer's position statement back in July. My attorney has been working on the rebuttal, but it has been 4 months and nothing. What do I do? Well, I would ask the attorney to see what they've got so far. Like, listen, it's not impossible that the attorney arranged 4 months of extension time to work on your rebuttal. That certainly can happen. But 4 months is a long time for rebuttal. So like, I would like to see, hey, why don't you give me what you got so far? Let me look it over. Let me see what you're working on. Right. And if the answer is we haven't done anything, I have concerns. We need to have a conversation about why. Why have you done nothing on my case? I'm paying you a lot of money or a big percentage of my case. Like, why is nothing happening? This is concerning. Right. Like, have that conversation. Stan, I believe I already answered this question. AR American says, my attorney filed a motion of limine and it was ordered. What are some possible evidentiary defenses? Oh, what are some possible evidence defense would try to use to gain an advantage? I don't know the context of your case. I don't know anything about your case. I'm sorry. I apologize. I could not begin to answer that question without knowing more about your situation. Carlos Gomez says, hey, Vince, I have a collective action lawsuit in Western Tennessee. Congratulations. The judge approved the collective action. Congratulations. My lawyer said the defendant's side wants to settle a lawsuit ASAP. Congratulations again. That's great news. I'm really glad to hear you are succeeding. You have counsel. They're doing well for you. Love it. Valencia says, is it okay to request to ask what they said? Is it okay to request to ask what they said that they would countersue you for X amount of dollars? Can you ask for that much in case you do get sued by opposing counsel? Is it okay to request to ask what they said? So I think you are asking about like a confession of judgment situation in California. I am not qualified to advise you about the state laws of California, nor am I allowed to do so. You need to check with local counsel. Generally speaking, in New York, there's a confession of judgment. It does not change your damages. So I don't necessarily know if what you're proposing would work, if I understand it, but got to check with local counsel. I'm sorry. I apologize. Top Op says, hey, what happens if an employer files for Chapter 11 bankruptcy after I file with the EEOC? How will this affect me? If we are already in conciliation and the starting number is $90,000. Well, a Chapter 11 bankruptcy is a workout. It's a workout bankruptcy. So they're in bankruptcy and they're looking to shed some debt and restructure their debt and get back to making money, which is good and bad news. It's good news because that employer is still going to be there. It's bad news for you because you might not want to settle that case for 90 grand right now. They're in bankruptcy. We don't know how long they might be in for bankruptcy, but certainly if I was looking to settle a case and I had a case about to settle, and then I saw the employer going into a Chapter 11 bankruptcy, I'd probably have a conversation with bankruptcy counsel about if I need to hold the settlement off until after the workout bankruptcy. So I would advise you to have a conversation with the attorney and say, hey, attorney of mine, you are swell and I am paying you a fat percentage of my case. How about you go grab a bankruptcy attorney and we put together a plan to see if I can accept the settlement now or if I should be waiting. Carlos Gomez says, do you think I will be able to get all my damages? I was a supervisor and I have all the emails, text messages, and work orders. What percentage do you think I'll be able to get? Carlos, I have no idea. I don't know anything about your case. I'm so sorry. I don't know anything about your case, so I can't give you any idea of what you might win or what you might hope to win or what the risks are. Collective actions. Listen, my concern with collective action and class action is that often the attorneys make a lot of money and the claimants make a little bit less than they should, in my opinion. But that being said, doesn't mean it's necessarily going to happen to you. Valencia says, look up Zavala v. Scott Bros Dairy. Okay. AJ SoFly69, is it normal for an attorney to not really be informative when I have questions because the EEOC is still investigating? No. you have questions, part of our job is to answer them, right? Like if you ask me what the EEOC is going to do in a given case, the answer is going to be probably issue a right to sue letter. But if you're asking me like, what did the investigator think about the charge of discrimination, I don't necessarily know that unless I had a private conversation and the investigator disclosed some things to me, right? Which happens, but doesn't happen in every case, right? So like if you're saying the attorney's not answering your questions at all, I have concerns about that. If you're saying the attorney doesn't know some things because the EEOC is still working, well, that does make sense to me. I hope that helps. AR American says, what's a good strategy if I lowered my demand and the defense didn't respond? Should we raise it back up again or lower it some more? AR American, I don't know the situation, so I can't say. I guess it all depends on where you want to end up, how bad you want settlement, what your appetite for risk is. Like there's a lot going on there, right? So I would definitely be thinking about all of that and having frank settlement discussions with your attorney to figure that out. Amen King says, hello, Vince. What happens if you find a symbol of hate at work and you have a retaliation case going? Does that make your case more valuable if you win? It could certainly support your case in certain contexts. Yeah, it would certainly support the, it would potentially add to the protected activity that you engaged in if they're related, and establish kind of the, like what's going on in the workplace. So we have a bunch of people telling me that my mic was muted. I apologize for that. Hopefully everyone hears me now. Stan Stokes says, okay, I haven't gotten to the EEOC stage yet. Okay, that's fine. So Stan, I still don't think whether the EEOC or not, the personnel file is not a big concern for us. It's just not. Unless there's something in there that's like you got into a bunch of fistfights at work or something like that. Like it's usually not as important as you think, because a lot of it goes into a personnel file is going to be like a pretext or like fake discipline. There's a lot of stuff like that goes on, right? They often try to paper your file when they think you're going to bring a discrimination case. Samuel Raja Sakar says, lawsuit for minor wage theft was going. I was fired, got letter, not working out. I immediately filed it through e-file. Okay, I already answered this. AR American says, can the employer's position statement be very strong evidence against them if I have a very well-detailed and persuasive rebuttal? Yeah, if you can show that the employer is lying in their position statement, that can be really, really useful evidence. Amen King says, the New York State Division of Human Rights has my case. I was told by New York State it takes about 180 days. It's been a year. How long can they hold it? I've seen the State Division hold a case for up to 2 years. It's very rare, but it happens. Hush Money, YouTube user Hush Money, great username, says court ordered 2-step mediation. My attorney sent our discovery request late. We have given responses. Is it advisable to initiate the mediation without discovery? Ask for a higher settlement, maybe. So this people keep bringing this up to me. There is routinely mediation before discovery. I don't know who's out there telling you can't have mediation before discovery. It's just not true. I don't even think it's really an advantage. Recently, someone was screaming at me about this, and it's just like, yeah, there's a reason why the court has. So federal courts in New York and in many other jurisdictions just have an immediate mandatory mediation way before discovery ever happens, because it can work out great for the plaintiff. It can definitely dispose of cases. It can be very efficient. Like if there's something you think you need to prove your case, that's fine. Just conduct the mediation early on like you're going to get it. And if you don't get it in discovery, that's fine. You can drop your demand later. You don't have to like have the discovery in hand to go to mediation. Just don't settle at the mediation if you don't want to settle. If they're not properly fearing you because you don't have what you need yet in discovery, that's fine. Don't settle. Just don't take the deal, right? But either way, you still got a lot of information about their stance, what they want to pay, some of the strategies that they're trying to use to discredit you. Yeah. Vivian H says, I think my EEOC rebuttal statements explain my case better than those intake questions. How can I submit rebuttal statements to attorneys? Vivian, so we routinely we'll take all the filings, the EEOC charge of discrimination or sexual harassment, the position statement, the rebuttal. We'll review that all the time. Any firm that doesn't want to review your docs, I have questions, right? Because theoretically, the attorneys are looking to pour tens, if not hundreds of attorney hours into a case and potentially either front or cover your expenses, right? And that can be tens upon tens, if not more, of thousands of dollars. So what kind of attorney doesn't want to review the docs before they make that leap, right? I just have questions about that. So yeah, any firm you offer that to that doesn't want to, I have questions. Broderick says, could discovery reveal avail during a wrongful termination case? And if so, would that prevent a defendant from avoiding punishment? Could discovery review avail? Do you mean you're worried about piercing the corporate veil? Is that what you're talking about? Give me a little more, Broderick. I want to answer this question, but I need to know what you mean by avail. GB, thank you again for those $2 here. Let me give you the, I give you the like. Let me give Mr. Stan Jokes the like. Let me give Shanice Robinson the like. Thank you so much. You're very, very generous. If you have a question, GB or Shanice Robinson, please ask away. I will get you answers, of course. Why Thomas 777 says, my counselor told me it's hard to get diversity in the jury pool for federal cases of discrimination. Has this been your experience or knowledge? Well, it depends where you are, right? If you are in a jurisdiction where your federal court pulls this jury pool from a very diverse population, then the answer is no, not hard at all. It's very easy to get diversity in a very diverse place. If you're in, I don't know, let's say Wyoming or Montana, well, not as much diversity in that population, and that jury pool might look a little Caucasian, right? Which doesn't mean they're not going to do right by you, but I can certainly, for technical reasons, understand why you might want some diversity in certain kinds of cases. And it really comes down to what is the jury pool? That is what determines how easy it is to get diversity in your jury. Palencia says the cutout cardboards will be reserving those seats. Yeah, right. No one's spending 90 grand for those seats. It's nutty. There's no chance. Who's going? Usher? I mean, nobody's going to that game. Not for 90 grand. Ink Vein said, I was wrongfully terminated after uncovering something really bad at my job, and my employer's attorney is calling me trying to negotiate a payout. And I can't afford an attorney to represent me. Well, Ink Veins, I mean, probably an attorney would work on a contingency for you there. But I wish you luck with that. I'm really sorry. VA says, hello all, be sure to hit the like button. Vince is doing what most do not do, and he is doing it for free. Thank you very much, VA. That's very kind of you. And also, thank you everyone who hit the like button. We have 60 concurrent people and 37 likes. Those likes really help us. It'd be awesome if it was 60 concurrent viewers and 60 likes, but I get it. Maybe you don't want to hit the like button. It costs you nothing, but that is how the algorithm sees us. Okay, let's see here. NYC Damages said, could you say we experience employment discrimination forward and build our case lawsuit backward, proving it from the end in mind, matching our evidence and skipping some details, just backward proof. Yeah, I mean, to an extent, right? You experience the discrimination on a linear timeline, right? All humans, to the best of my knowledge, experience a linear timeline. We're all just going forward in time. The physicists say there might be other ways to go besides forward in time, but as far as I know, none of us have done it yet. So yeah, we experience it going, forward. And then in the future, you're thinking about things that happened in the past. So there is some component of trying to backfill and prove the events of the past in your case, right? I hope that's what you meant. Amen King said, apart from my case, I was being harassed at work and it made me really sick, physically sick. The day I was fired, I got sick from the name calling. I asked if I could go home because of the sickness. I'm really sorry, Amen King. That's horrible. I hope you're okay. Amen King goes on. Once I got home, they called me and fired me. Does that show retaliation or anything? Well, listen, it can be retaliation if you engage in protected activity. Like if you oppose discrimination or oppose sexual harassment or made a complaint of sexual harassment or discrimination and they fired you as a result, could certainly be a claim. Yeah, could be retaliation. Automation 4 says, hi, Vince. Were you able to get your Scottish Highland cows yet? I have not been able to. I have had a couple of negotiations go awry. Like my Scottish accent is not good. I'm going into Scottish accent because they're Scottish Highland cows, Scottish Highland cattle. No, yeah, I've been trying to buy cows for a little while now, and it's just like it's that time of year where people don't want to winter their cows. Overwintering cows can be like a big hassle because you got to keep going out to like warm up their water and break the ice up and everything. So a lot of like small time farmers do want to sell their cows this time of year, but we have some disagreement as to like how much those cows should be worth. So it's not yet been a successful endeavor. I just keep buying more pigs instead, or trying to. Natural Intellectual says, I was terminated without the accommodation process the day after I returned from medical leave. No performance improvement plans. I signed a severance contract. Can I still have a case if I prove disability discrimination? Well, listen, I don't know what was in your severance contract, but the point of that severance contract most of the time is to have you sign a release so you can't sue anymore. So what I would urge you to do is take your severance agreement to a local attorney, have them review it and tell you if you can still sue or if you sign a release giving up all your claims. Lean Team says, whoa, chat jumped ahead. Whoa, chat. No. I got to find Lean Team. I'll tell you, they need a better chat function here. I guess there's nobody else who's just like reading through chat, answering questions. I guess that's just me. Okay. Lean Team says, hey, I've been assaulted at work and then fired for verbal language. I'm really sorry you were assaulted. That's horrible. Now, was it a sexual assault, an assault motivated by some form of discrimination, or just a physical assault? Liam goes on. I emailed HR, then was put on unpaid leave. Then I was taken off unpaid leave. So I emailed HR about not feeling safe to return. Now they have fired me. Again, after calling out the past 2 days. I'm really sorry. I would run that by a local employment attorney. If there's some kind of discrimination or sexual harassment in the mix or retaliation, that could absolutely be a claim. You could also, listen, if you're physically assaulted, consider talking to the police. You could file criminal charges there. YouTube user AR American says, on their position statement, they stated I had poor performance, but weeks prior to my termination, I was promoted and received a raise. Pretext. Yeah, I would say that sounds like a pretext to me. Shanice Robinson said, I just hit the like button. No question. Just appreciate you for what you do. LOL. Shanice, thank you so much. That's very kind of you. Thank you. NYC Damages says, is it harder to prove disability discrimination if they're treating some disabled staff bad, but not all? In other words, would they have to mistreat all in order for a jury or judge to find them guilty? No. If you can prove that you, specifically just you, received disability discrimination, that's good enough for the purposes of your case. Queen T83 says, hello, happy Friday. Well, thank you, Queen T83. Is that like T83 like the calculator? I think I had one of those in high school. Superficial looks. Do you advise against sending your rebuttal to the company? Or just let the EEOC handle it? Seems like it's just a waiting game after you submit the rebuttal. So I do in certain situations share rebuttals with opposing counsel. It's when I think the rebuttal is going to shake things up negotiation-wise and get something moving for my client. Queen T83 says, I'm currently in my deposition phase. My previous supervisor is lying about everything. How'd that play out during the actual deposition? Well, if the deposition goes well, and if your attorney was able to hold your supervisor accountable for those lies, that supervisor is going to have jack all credibility left out of that deposition, and you're going to be in a good place, potentially. Superficial Look says, thank you for your help. It's so scary going up against a huge insurance company. I can imagine that being scary for a pro se litigant. Yeah, I'm not surprised at all. Stephanie Patterson says, thank you, Stephanie. Thank you. Thank you for being here. I hope I'm helping. I hope I'm providing value. Oh my gosh, we have 60 concurrents and 51 likes. Thank you all so much. That's very kind of you. Nico Gomez says, what should you do if your attorney lied to you about taking your case, and in that your case has been closed and the attorney that said that is no longer working for that company? Well, have you lost your case? Is your case dismissed, or can you file your case again? Find that out first. Find out if you're still within your statute of limitations, if you can still file your case. Listen, if that attorney like took your case and then did nothing, that could be malpractice. You could talk to a malpractice attorney. You can talk to the bar association about filing a grievance. If you paid that attorney money, you could file a fee dispute against that attorney. There's a lot you can do in that situation. BMCK says, why is it so hard to find an attorney when a case is already... Why is it so hard to find an attorney when the case is already in pretrial litigation? What can I do to help myself find an attorney during the discovery or deposition phase? Why does it feel like now it's late to find an attorney? BMCK, were you handling it pro se, or were you represented by someone else? If you're represented by someone else, I would just get a letter from that prior counsel being like, hey, no harm, no foul. We just parted ways. We're on good terms. And that should really help you find an attorney going forward. If you were pro se, it can be really hard to find an attorney. A lot of firms, including frankly our own, we're really reluctant to take cases over from pro se litigants because it adds so much risk and so much extra work for us that it's like, we would have helped you if we could have gotten on the case at the beginning, at the EEOC phase. But when people handle the case themselves pro se, there's so much that you have to try to fix and find, and like it's kind of like the difference between building someone a house from scratch and then like somebody who doesn't really know how to build a house, no offense, pro se litigants, building a house and like putting the sheetrock up and the siding up and painting everything, and you can't see all the problems, but anything could go wrong. The electric could burn the house down because the person didn't really know what they're doing. The support structure might not be right, and just the whole thing collapses on you, and you don't know, and you've got to start like slowly trying to take the house apart, figure out what's wrong with it to fix it, and that takes so much longer and is so much more dangerous and risky than just starting the case from scratch. That like if you're pro se, it can be really hard to find counsel. Ryan Whitney says, any thoughts on the decision published in favor of the U.S. Naval Academy? Haven't read it. I apologize. Affirmative action is a very complex topic. I'm just doing workplace discrimination, workplace sexual harassment cases. I think diversity is a good thing. Fundamentally, I think there's real value to diversity. I think a lot of the ways affirmative action was used was questionable, but inherently diversity is incredibly valuable. So it's a difficult and tension-ridden conversation. Okay. Robert Coriano says, I was writing a performance advisory, pre-PEP, with lies. My manager reported no improvements on paper after provided a verbal positive. Continued feedback to me. I asked him, that's just regular PA words. Okay. YouTube user Carlos Gomez says, excuse me, after the federal court has approved my collective action for misclassification, what's the chances to get all damages my lawyer calculated, since I was a supervisor and I have all the data and evidence? If you have all the data and evidence, you can prove everything. It sounds great. Sounds like you're sitting pretty. I can't give you a probability. I'm not really familiar with the case, but it sounds like you're doing well. TGN TV says, I just filed a lawsuit against my former employer because one of my coworkers called me the N-word. I'm really sorry. I then reported said comments to the executive director of the company, and I was terminated the next day. Woo! That sounds like both a discrimination and a retaliation case right there. That sounds like a hell of a case. I hope you get paid big. I'm sorry you dealt with that. Why is the EEOC in Florida taking so long for a decision? I don't know. Maybe because they're overwhelmed. There's too many cases. Maybe because they're government workers. Maybe because there was a hurricane. I can think of a lot of reasons, but I don't know specifically. And we are back. Okay. YouTube user Superficial Look says, how do you request information from the employer during your EEOC investigation? I don't have an attorney yet. I'm able to request documents. Could this be a subpoena request? So I think if you don't have counsel, you don't have representation, the best thing you could possibly do would be to ask the investigator if she or he would demand those documents from the employer for you. They may not. They can. They may not. You'll later be able to get discovery in federal litigation if you go on to federal litigation. Agree to disagree with me. Vince, I finally caught you live. Thanks for all you do. I have a unique case. I hope that you win your case. CJ42 says, are there any post-Pandy 19 or circumstantial exceptions to filing time limits? If you are talking about the EEOC filing statute of limitations or the right to sue statute of limitations, none that I'm aware of. Agree to disagree with me says, my employer also provided my housing. They gave me a vacate notice. Then when I raised concerns about a material change, they canned me. I declined to accept your severance offer. Now they are calling, asking if we can work things out. As my lawyer said, we will file. As my lawyer said, we will file. If I received a call from HR asking if I'm willing to talk more, what are your thoughts on my leverage? We are claiming wrongful termination, retaliation, among many other things. Well, I'd have a conversation with your attorney, right? So I don't know anything about the case, but listen, you can look at a lot of superintendent cases in New York City for that kind of situation where there's discrimination or sexual harassment that goes on and they're forced to vacate their apartment because they often live in the building they take care of as part of their compensation. Have a conversation with your attorney. About the risks in the case and what you think is a good option and what your demand should be. And then if they want to talk about paying you, have the conversation. Just don't agree to any settlements you don't want to, right? Ooh, I'm getting hungry. I need a protein shake here. My goodness. All right. Skylar Wildwood says, EEOC complaint filed for discrimination based on a race and disability. Position statements and rebuttal filed. I made reference to recordings in my rebuttal. Transcribed parts. How will that affect my case? Sounds like you did everything great. Well done. Valencia says, if you are suing a company, when is it too late to bring charges against the union that was supposed to represent you? Well, generally speaking, and check with your local counsel, but generally speaking, the statute of limitations to bring a discrimination claim against the union, in my experience, is about the same as the statute of limitations to bring a claim against your employer. So, check your statute of limitations wherever you are. Those are your statute of limitations. Check with local counsel to make sure they also apply to the union. Agree to disagree. What are your thoughts on my leverage? We are claiming wrongful term. Oh, I already answered this. Okay. AR American says, so I suggested we depose the CEO. My lawyer told me they would block it. Any advice? Well, listen, if there's a reason why the CEO was a direct witness of what happened to you or had some involvement in the decision-making process, I think your lawyer can probably fight that attempt to block it and oppose it and potentially win. If you're just trying to depose the CEO, but the CEO had nothing to do with your case, good luck. Not going to work, probably. Excuse me. Rebecca Baldaws says, Vince, I filed on September the 9th of 2023. I'm going to San Francisco District Court. I haven't been given a name of a judge yet. Happen to know how long these cases take? There or where you are, how long does it take to have AJ? Administrative judge? Generally speaking, so people call the New York docket for federal court system the rocket docket, and I rarely see cases go over 2.5 years. Sounds like your case is going pretty long. I'm not familiar personally with the San Francisco District Court, so I don't want to tell you how long a case will take there. The longest federal court case I have ever seen, well, the longest case I've ever seen was 4.5 years, but that was actually largely because of the EEOC. The EEOC held the case for a very long period of time, and my client consented to the EEOC holding the case for a long period of time because she liked the investigator that we were working with. But overall, the EEOC and federal court altogether took 4.5 years. Generally, federal litigation that I'm used to is done within 2.5 years. Superficial look says, any cases won in the employee favor that for ADHD and anxiety discrimination, any that you're aware of? There's a lot of cases, especially for anxiety, but there's a lot of cases for ADHD as well. So ADHD and anxiety are both valid disabilities under the federal law, due accommodation. With ADHD, the question is always like, were the accommodations reasonable? You know, that it's always a question around ADHD, and to a lesser extent with anxiety, although people tend to give anxiety disabilities less grief than ADHD for whatever reason. All right, take a quick break. We're back. I've been on live for I think an hour and 12 minutes now, and in that time I have 45 new emails. I may not be leaving for the farm quite as soon as I'd hoped. All right, let's find, where were we? I'm probably going to go another 20 minutes about. Just trying to find where I was in the chat. Okay. YouTube user BMCK says, is that BMAC? How should I pronounce BMCK? I digress. If you're forced to represent yourself pro se in federal court for a race discrimination or retaliation case with good evidence due to inability to find a new attorney, what's my best general strategy? How do I initiate communication with defense counsel? Email them. Just shoot defense counsel an email. Say, hey, defense counsel, I'm representing myself right now, so you're allowed to talk to me. I have a settlement demand. Do you want to have a conversation about settlement? And see what they say. You can also be like, hey, this is going to get real expensive. I'm about to hire another attorney for the trial portion of this case. And I thought, in this brief moment when I'm not represented, we could talk about going to mediation because, hey, listen, I'm open to settling. And right now I wouldn't have to pay an attorney. So I might be willing to settle for a little bit less. You want to have a conversation about that? You want to get that mediation scheduled? That might be what I recommend to you, BMCK. Listen, the reality is that conducting a trial pro se, nightmare. Just absolute nightmare. Like, I've seen attorneys who are not really trial attorneys try to conduct trials. Oh my God. Like, part of me died watching this person try. I can't imagine. They will probably remember that day for the rest of their life as just a living monument in their memory of their failures. Like, it's just horrific. And that's someone who was like actually trained to do trials, but just hadn't done them yet. Like, didn't, doing it pro se is incredibly difficult. So if you're going to go pro se without representation to trial, like, settle that case. Get that case settled if you can. Sorry. I know it's not the best answer, but it's the most sincere one. YouTube user Vivian H says, prohibiting an employee from expressing their political beliefs is illegal under the California Labor Code 1101/1102. So I can't comment on California state law, but thank you for telling me that. Freeway 42 says, why do employers deny mediation? Well, they may not want to pay the attorney to go have a settlement conversation with you if they don't intend to settle the case, or they may not want to pay the attorney to go spend a day talking settlement with you if they think your settlement amount is unreasonable or too high. Amen King asks, Vince, as New York State has my case, is a judge still working on settling the case? I don't know, Amen King. I don't know what phase your case is in. Last I think I knew about your case, it was in the New York State Division of Human Rights. If it's received probable cause, you might, in fact, have an administrative judge scheduling a conference that would include some settlement talks. If it has not yet received probable cause, there's probably no administrative judge involved. Shanice Robinson said, I can't find much online regarding the company filing a subpoena for phone or forensic examination. Do you have any videos on this? So the company is seeking your phone. For a full examination. Do you have the same phone that you had when you were employed there? I mean, if you have a different phone, right off the bat, it's a great argument. Hey, it's not the phone that I had when I was there, so this is not relevant. You can't have this. And I would make that argument. If it is the same phone, I mean, I would certainly fight that. And I'd fight it under the argument that, like, hey, you can ask us for records. Like, if you want screenshots of certain conversations, we're happy to provide those, but you don't get to just peruse my entire phone, right? Like 99% of my conversations and data has no relevance to this case. So why would you get to peruse my entire phone? And they better have a good reason, right? I think you can certainly oppose that subpoena with some success. Roderick says, also great username, Roderick. Yes, that's correct. Piercing a corporate veil where there's multiple LLCs and transfer of responsibilities. So, Roderick, it can be a hassle. If you're not represented, it's a big problem. If you are represented, listen, attorneys are fairly good at piercing the corporate veil. There's a lot we can do. And the valuation on an employment case is high enough that it's worth the attorney's time to actually go through that process of, going through the various LLCs and tracking down the money for you, so to speak. Okay. What do we got? T-Boz05 says, hello, Vincent. I received a compliance determination letter that my employer uploaded in my EEOC portal, but I can't view it. Then I received a compliance determination letter. I can't view. What does it mean? I received a compliance determination letter notice that you can't see? I don't know. I'd call your investigator. If you're not represented, I mean, listen, if you're represented, just call your attorney and be like, hey, attorney, find out what's going on here. But if you're not represented, you're going to have to call the investigator yourself. See what's up. Okay, Vivian is posting California labor codes, but Vivian, I think I already mentioned, I can't advise you as to California state law. So you're asking questions about California labor codes that I'm not allowed to answer for you. I apologize, Vivian. I'm not licensed in California. So even if I had an answer for you, if I gave it, I would be imperiling my license, and not going to do that. I'm sorry. YouTube user Trivia Burst. Oh, 10 minutes left. 10 minutes left on the stream. 10 minutes remain. Trivia Burst. My company had a discrimination case in 2008. Per retention, physical copies have been destroyed. Would having just the case number be relevant to prove my company has a history of discrimination? Well, per retention policy of who? Because if that case went to federal court, I believe it would still be on Pacer. It'd still be available. Like I understand that they're getting rid of physical copies, but the e-copies would still be on Pacer, I believe. So I checked that out. In terms of just the case number, I mean, I guess the case number would prove that a case existed, but you would want more than that, right? You would want the affidavits from that case. You would want the complaint. Like, you'd want to know who was involved. There's a lot more you could get to be useful to you from that case than just the case number, if you can get a hold of it. So I would check Pacer. Dana Carhart says, the EEOC contacted me and said the company stands by my termination, but would be willing to mediate my case. Is this good? I have an arbitration hearing with my union on January the 28th. Yeah, it's great. So they want to sit around and have a conversation about giving you money to settle your case. Now, you're going to have a good long think about what you would and would not accept, and whether or not you would accept a deal that ends your employment, or if you're looking for a deal that brings you back to employment, right? You're going to have a lot to think about here, but if they want to mediate, sounds positive to me. High-class problems. All right, 8 minutes remain. YouTube user A. Watkins says, I had a reasonable accommodation request from DR, but the employer insists I didn't have a disability and never accommodated, and they never made an accommodation request. Is this logical to say I don't have a disability if the accommodation was requested? Well, listen, I've seen a lot of people who request accommodations who don't have disabilities. That's way more common than you'd think, right? I get lots of calls from people who are like, yeah, I asked for an accommodation. I just need to be late sometimes. I'm like, oh, do you have like a disability that makes you be late? Like, what are we talking about here? And the response will be like, yeah, it's just hard for me to wake up. Okay, so you need to go like get a diagnosis of a disability in order to like be able to ask for reasonable accommodation. Generally speaking, listen, there's immediately going to be somebody who's like, you don't need a diagnosis. No attorney is going to help you unless you have a diagnosis. So like, get the diagnosis. So A. Watkins, like, listen, just because you ask for an accommodation doesn't prove you have a disability, but it does prove that you advise them of a disability. I presume that you like mentioned some disability in your accommodation request. And I think it could be proof of that. I also assume you actually have a disability. So put that all together, sounds like a pretty compelling argument that you had a disability, that you shared that disability with the employer, and that you talked about an accommodation, right? Now, they can dispute the validity of the disability, but they can't, in that scenario, necessarily dispute that you brought it up, right? Dana Carhart says, after 30 years in my company, I was terminated based on claims by 2 supervisors who alleged that I called the company woke. As someone covered by a collective bargaining agreement, I'm particularly concerned about whether the terms of the CBA were violated in the process. Would mediation with the EEOC affect my arbitration hearing or any potential outcomes? Whoa. Rebecca, thank you for the $5. That's very generous. You do not have to give me money. Thank you so much. Okay, let me go back. I'm going to finish answering that question, and then I'm going to go to Rebecca's question. Where are we? Okay. So Dana Carhart was saying, would mediation with the EEOC affect my arbitration hearing or any potential outcomes? If you settle at mediation, depending on what is in the settlement agreement, it could also impact your arbitration. So you could choose to settle your case in a way that gives up your right to arbitration. You could choose to settle your case in a way that gives up your employment. You could choose to settle your case in a way that returns you to employment and invalidates the need for arbitration. What you agree to in mediation could certainly impact your arbitration. That being said, you don't have to agree to anything in mediation. So it doesn't have to affect your arbitration. See what I'm saying? Oh, Dana goes on. Should I coordinate both processes to strengthen my case? And could settling through mediation impact my ability to pursue further legal or arbitration remedies? Yes. If you settle your case, generally, most settlements are going to be a full release of claims. So unless you have new claims that crop up, or unless you somehow settle your case in a way that has carve outs, so that not all your claims are dismissed or released, then yes, it would invalidate your ability to go forward. Now, just settling the discrimination case, if you're very careful in how you settle or in how you had that settlement agreement drafted, you can do a carve out. So you can settle your discrimination claims, your sexual harassment claims, whatever it is, and have the settlement agreement drafted to say, hey, we're settling these specific claims and only these claims. And Dana Carhart still has a right to proceed to arbitration as per her collective bargaining agreement. Okay. Thank you, Vivian, for hitting the like button. Thank you. Shanice Robinson said, employers aren't liable for physical assault, non-sexual. They can be in certain situations if they were negligent, but generally physical assault cases that are not motivated by discrimination or sexual harassment or retaliation are not all that valuable against the employer, at least. There's a lot of civil assault claims against the person who assaulted you, but the validity of those claims against the employer, unless they had some reason why they should have known this was going to happen, they should have known they should have protected you, there might not be that much against the employer. Every situation is different. Okay, I got to find Rebecca's question. All right, Rebecca gave us $5. Thank you so much, Rebecca. What is your question? Oh, did you just saying thank you? Rebecca, I'm here to help you. You don't have to give me money. Thank you so much. It's very kind of you. So listen, it's amazing when y'all give us money, but like give us the minimum amount just because it helps us in the algorithm. You don't have to give us money at all. First off, you don't have to give us money at all. But if you're going to give us money, you don't need to give big amounts. Like, I don't know what the minimum is. I think it's like $1 or something. That's plenty. Anything you give super duper helps us in the algorithm. It helps people find the channel, stuff like that. But so generous. Thank you so much, Rebecca. It's very kind of you. So many people gave today. Very kind of you. I'm just saying, like, give the minimum. I appreciate you very much. All right. Last question. What do we got? We got Aristotle Rush says, hey, Mr. Vince. Oh, chat jumped. Whoa. No, Aristotle Rush, come back. I got to find you now. Okay. Hey, Mr. Vince, I hope your evening is going well. My question to you is, should you have to give the defendant all of your medical records to substantiate mental anguish damages? Generally, yes. I'm sorry. I know it's frustrating, but when you're putting your mental well-being in question to receive emotional damages, generally speaking, the employer is going to have access to your medical records. I'm sorry. Okay. You know what? I got time for one more. We got QQ Bella says, my employer down-leveled offer after interviewing me. I was paid much less. Whoa. QQ Bella deleted the question. All right. I will not answer the question. Oh, here we go. Amen King says, Vince, I didn't know how hard it is to go to a white person to tell them another white person was being racist towards them. That is very hard for some to do. Just the information for you in the chat. Yeah, I get that. So like one of the big things that I'm aware of is that I look like the problem for a lot of people. There's a lot of people who come in and tell me about discrimination and they're like, yo, this guy looks a lot like the bad guy. And listen, there's also a lot of women who come in and tell me about sexual harassment. And I'm sure they're sitting there like, I'm alone in the conference room with a guy twice the size of the bad guy who did bad things to me. Not that I'm like so huge or anything, but like, you know, I look like the problem and I'm very aware of it. And that sucks. So we do like, listen, a lot of people will be like, hey, can I have a female attorney? The answer is yes. Yes, you can. A lot of people are like, hey, Vince, you seem like a nice guy. I just don't really want to work with you. Kind of had my fill of white people for right now, which I get. No harm, no foul. I send a lot of people, and she's coming on the channel very soon. We actually just filmed a collaboration, which we're going to be, I think, posting in the near future. Marjorie Mesdor, tremendously talented attorney. Great pedigree. Used to be at Phillips and Associates, then went to Wigdor. of the P. Diddy case fame. I think it's Wigdor and Associates. I don't know the name of the firm. And she's now got her own firm. She's out there. She's a woman of color. And I sent a lot of people her way. Like, yeah, I get it. I get it. I look like an asshole. Also, frankly, I am an asshole. I think I'm less racist than average, but like everybody's a little bit racist, right? Like no one's perfect. That's just the reality of racism. Like there's a weird thing in human beings where like we are aggressive towards the other and we watch TV and we like media and people say crazy things about certain communities. And I grew up with problems with the French Canadians, the Quebecois. I have my own very real issues. When I hear someone speak that special kind of French, my spine starts tingling and I'm like I get a little crazy and I gotta be like, no. These are not the people that you grew up with. This is a different person who's done nothing to you. But we're all imperfect in a variety of ways and everybody's a little bit racist. Everybody discriminates a little bit. So like, I'm not offended by that at all. Yes. Jingle Cat, to your point, bias. We all have inherent bias. We do. 100%. I'm not doing a good job of explaining this, but like there needs to be more representation in the world of employment attorneys. There's not enough women. There's not enough people of color. It's a real problem. There's a lot more on the defense side than there is on the plaintiff side. And I think part of that's just that defense firms will pay guaranteed money, like $400, $500, $600K a year, guaranteed, to get a talented employment attorney to leave the plaintiff side. Excuse me, and go do defense work because they need people of color and women to sit at the tables with the bad guys. It's very important for the optics for the jury. And so they'll stuff it. Okay, TJN TV, what's the last question? All right, I'm gonna answer. TJN TV, you get your question posted real quick. If you can ask it. Aziza J, I can't recommend attorneys, but we did have a very talented employment attorney from Illinois on the channel a while ago. I'm not allowed to recommend any attorneys, but that's a person that is an employment attorney in Illinois who I thought well of. Beatrice Martinez says, so if you have an FMLA case open during the time you made a claim with the labor board and then placed on suspension, then terminated right after that, is that a protected activity? Yeah, I mean, potentially you engage in protected activity there and you would have a potential retaliation claim, I believe, based on what you've shared with me. Last question. TGN TV, should I take it to trial? I'm nervous about the deposition phase. It's starting next month and I don't know what to expect. So TJN, I can't tell you if you take something to trial or not. It's all about your appetite for risk. All about your appetite for risk, the strength of the case, what you're looking for, what they're offering in settlement versus what you might win at trial. You know, it's a big totality of the circumstances decision. I can't begin to tell you what's right. Jingle Cat, can obesity be perceived as a disability that the person is just lazy rather than genuinely sick or disabled? So if you have a medical condition that causes your obesity can be a disability. If you have a medical condition that causes you to be unable to treat or deal with your obesity, then obesity can be a disability. If there is no medical reason for your obesity, it's probably not a disability under federal law, although that could be different in certain jurisdictions, but under federal law, probably not. All right, everyone. We've been going for 1 hour and 35 minutes now. I hope everyone's well. I'm sorry. I don't do case law on the channel, Sean Frank. I don't talk about case law. I apologize. I hope everyone's doing well. Try to give as many answers as I could. I hope it was helpful. Like, subscribe, comment down below. Share the channel so it will grow. Take care, everybody. Have a great weekend. Enjoy this time of year. It can be a beautiful time of year.